Tom Scroggins. I'm a partner with the law firm of Burr and Foreman. Appreciate you making time to join us this morning. We do these Burr morning shows about once a month. I think this is the second one that I've done this year because my area of practice, labor and employment, especially the labor aspect of it, has been pretty busy this year. There's been a lot of developments, and we're going to talk about some of those today. For those of you who have worked in the labor relations arena for a long time, you'll hear some things I think that will be very surprising to you. The game has changed quite a bit. The National Labor Relations Board has been very, very busy this year, and frankly, for the last couple of years, but have particularly made some new rules and issued some new rulings that are going to change the way, very dramatically change the landscape for employers responding to labor organizing drives, card signing campaigns, and how you respond to a petition for election being filed with the National Labor Relations Board. So why is this timely? Well, look, the big news this week, of course, has been that the UAW's strike against Ford anyway has been at least seemingly resolved, with the UAW announcing, I believe it was Tuesday night, that they reached a tentative agreement with Ford. Now, what's in that agreement? Well, it's a 25% wage increase over 4.5 years. Now, when this started out, the UAW demanded a 40% wage increase. Ford responded with a proposed 9% wage increase. They almost met right in the middle with a 25% wage increase. 11% of that is right up front upon ratification. So if the employees, the members, vote to ratify that contract, they get an 11% wage increase right off the bat. And the top out for hourly workers under this new contract is going to be at $40 an hour. Currently, that top out is $32 an hour, and the top out will be reached in 3 years instead of 8. So there's a pretty good amount of wage compression right there. So instead of taking 8 years to get to $32, now it'll take 3 years just to get to 40. Cost of living has been reinstated. That's been out of the collective bargaining agreement with or between the UAW and Ford since I think 2009. And one, I think, new provision, the CBA, that's not getting a due amount of attention is the fact that UAW has negotiated a right to strike during the contract over a plant closure. So what that means is if Ford decides to close a plant, then the UAW can go on strike in the middle of a contract. Now, that's a little unusual because one of the main reasons employers would enter into a CBA, or one of the common provisions in a CBA, is a no strike, no lockout clause. The CBA is supposed to buy some amount of labor peace, meaning that at least while the contract is in effect, the union and its members will not go on strike. In exchange, the company will not lock them out. Nobody talks about lockouts very much, but that is a negotiating tool that companies have. They can lock employees out. It happens, but it's not very common. But in this particular agreement, UAW has reserved the right to go on strike. So in reality, what they're after is they're telling Ford, look, Ford, if you close a plant, probably a gas vehicle plant, and start shifting production towards EV cars and plants, we will go on strike. Very unusual. So all that's happened this week. Now, the next step in that process is the Ford UAW Council, which is main leaders for the Ford negotiations. They will meet to approve the agreement, which they probably will. That happens this weekend. And then Sunday night, for those of you who are labor nerds like myself, Sunday night, the UAW is going to have a Facebook Live where they will review the provisions of the contract purportedly for their members, but anybody's going to be able to see it. And you can watch how the UAW presents this tentative agreement to its members, and then the ratification process will begin. The UAW members will vote on the contract, whether they want to accept it or not. And I'm here to tell you, I'm not entirely sure that this will be ratified, because the UAW went into these negotiations demanding a 40% wage increase and set very high expectations for its membership, telling them record profits equals record contracts. Well, this is already a record contract, but is it going to be enough for the members, or will the members think We've been on strike 6 weeks. Let's make it 6 more, see if we can get $45 an hour instead of 40. We'll find out next week. But what does all this mean? I mean, there's it's not just the UAW on strike, of course. There's labor unrest all across this country. Some of you may have noticed that Kaiser Permanente had 75,000 employees on strike. That's the healthcare industry. They're a very large healthcare employer out west for the most part. But 75,000 employees on strike. Imagine going to a hospital or a healthcare provider and needing some care and being turned away because they don't have enough nurses or CNAs or what have you to treat you. That went on. That strike lasted several weeks. Lost in the shuffle of the UAW and the big three, Mack Trucks has been on strike. That contract was settled just about 2 weeks ago, but they were on strike for about 3 weeks. And there's card signing activity everywhere. I suspect there's people on this call that have had card signing activity or have card signing activity right now. And we're going to talk about why card signing activity is frankly more hazardous to employers than ever, because the bottom line is that may be the only chance your employees get to decide whether they are interested in union representation or not. There may never be a vote, as you may be used to. We'll talk about that in a little more detail. But generally speaking, there's more labor activity across this country than there has been in years. There's more ULPs, unfair labor practice charges being filed with the NLRB, and more election petitions being filed than there have been in about 10 years or so. We're seeing a dramatic uptick in activity. And this fiscal year is ending. And so we'll find out pretty soon what the 2022 to 2023 fiscal year filing numbers were, but it's looking to be a record year. Now, while all these filings are going on, the NLRB and its general counsel, new general counsel that's been on the job a couple of years, has been doing its best to aid unions and make it a lot easier for them to organize employers. One of the things you see here is this general counsel memo issued by General Counsel Jennifer Abruzzo announcing her position that what she and unions call captive audience meetings, or at least compulsory attendance at captive audience meetings, would be unlawful. That's her position. There's a case pending before the NLRB that will get a decision sometime relatively soon, we think anyway, and determine whether an employer is requiring employees to attend meetings intended to educate employees about what it means to be a union, what it means to sign a union card during a campaign, whether that's lawful or not. Preview, I suspect that the NLRB is going to rule that compulsory attendance or required attendance at those meetings is unlawful. Those of you may have been through union campaigns in the past will know that's a very common strategy for employers in the middle of a union campaign. Then we have this Cemex Construction case that just came out at the end of August. Very dramatic impact. This is the case. We're going to talk about it in a little more detail. This is the one that's going to make it so that your employees may never get the chance to actually vote in secret why they want a union or whether they want a union or not. So what happened in the Cemex case? Well, this case had been pending in front of the NLRB for a couple of years, and this employer had conducted what is very common with employers who are in the middle of union campaigns, meetings, small group meetings with employees, and intended to educate them about what it means to sign a union card, what it means to be in a union, what unions really are, and ultimately required employees to attend, of course, paid them to attend the meetings. They get paid while they're just like they're on the job. And the board filed a complaint saying, no, that's unlawful. You can't require employees to attend these meetings. And ultimately, we get this decision that says, among other things, employer, if the union gets more than 50% of signed union authorization cards, then you cannot, you can't require the union to file a petition for an election. You may have to make the decision, or we'll have to make the decision. Are we going to acknowledge and recognize the union? Or are we going to file a petition for election ourselves? And, you know, you get these three options. If you get the union demanding a recognition, you can recognize them, you can file your own petition, or you can neither recognize the union and not file an RN petition. But that's very risky, because what's likely to happen is the board is going to hold that you have committed an unfair labor practice charge and will issue a bargaining order. So some of you may have heard about bargaining orders before. Previously, under this NLRB versus Gissel packaging case, it was very uncommon for, I'd say not incredibly uncommon, but these orders were only issued in extreme cases of unfair labor practice charges, where employers have engaged in chronic and systematic unfair labor practice charges permeating the workforce, where a rerun election could not be held in a fair and free environment. Now the board is saying, no, employer, if you choose to file a petition for an election instead of recognizing the union based on their cards, if you commit basically any unfair labor practice charge, it only takes one, frankly, then we are going to dismiss the petition for an election. There will be no election, and you will get an order requiring you to recognize the union as exclusive bargaining agent for your employees and commence to negotiating a CBA. So, what is the ultimate result of this? How does this process work? Initially, you get if the union collects enough cards, you'll get a letter from the union organizer demanding the employer to recognize the union, enclosing the cards or petitions for union representation that the employees have signed. That's in that white box there. And then from there, you have these three decisions. The first option is pretty short. You can decide to recognize the union and start bargaining a CBA. But I doubt anybody in this call is going to do that. So then you have to choose from these other two options. The middle one is where most employers are going to land. You're going to file a petition of your own for an election. And if you don't commit unfair labor practice charges, then you have an election, and we'll see what the results are. If the union wins 50% plus one of the votes that are cast, then they are certified as the bargaining agent. If they don't, company wins. But if the NLRB finds that there's any unfair labor practice charge committed, then it issues a Cemex bargaining order. Oh, by the way, unions file lots of unfair labor practice charges during the pendency of elections, accusing employers of all manner of unfair labor practice charges and violations of the NLRA, and that will only increase. This Cemex process certainly incentivizes unions to file many unfair labor practice charges, throw those things against the wall, see if just one will stick, and overturn the results of the election, or have no election at all, which is probably what will end up happening. And then this third option, an employer can say, look, we're not going to recognize the union, we're not filing a petition for election, essentially thumbing their nose at the National Labor Relations Board. In that case, the board will find that the employer committed unfair labor practices, will issue a bargaining order, most likely, and then the employer is left trying to appeal that order to a circuit court of appeals, essentially hanging their hat on challenging the NLRB's ruling at the circuit court of appeals. In other words, lots of litigation, lots of time, lots of money. So that's the Cemex decision, meaning the end result is if your employees are presented with a union authorization card, that may be their one and only chance or opportunity to decide whether they want a union or not. And I'm here to tell you, from time to time, employees sign union authorization cards or a petition for union representation for lots of reasons that have nothing to do with whether they actually want a union or not. Sometimes it's because their coworkers or friends that they work with have been asking them for weeks and months, and they finally decide, I'll sign this just to get them off my back, and I know that I'll get a chance to vote in an election in secret as to whether I want a union or not. That may not happen anymore. You need to understand, and your employees need to understand, that if they are presented with a union authorization card, which oftentimes isn't actually a card anymore, it's an electronic card they can fill out. They get a link texted to them on their phone, or they might find it on social media, but they fill out electronically. If the union gets enough of those, there may never be a vote under the Cemex rule. So that's a major, major change from what most of you are probably used to in the past. Most employers, frankly, at the first sign of card signing activity, don't do much, if anything, thinking that, well, we don't want to disrupt productivity. We don't want to agitate our employees. Well, if the union gets enough cards, they'll file a petition for an election, and then we'll have 4 to 6 weeks within which to conduct small group meetings, to educate our employees about what it means to be in a union, what unions really are, state our philosophy about working in a union-free environment. Well, you may not get that chance anymore if the union gets enough cards signed. And then, oh, by the way, if you do decide to file an RN petition for an election in the event you're presented with cards by a union, you're not going to get 4 to 6 weeks to educate your employees, engage with them, and state your philosophy, because in addition to Cemex, just within a few days of the Cemex decision, the National Labor Relations Board issued or reissued, frankly, these quick election rules or expedited election rules, which are not in effect today. They will go into effect December 26th of this year. And the bottom line is that from the time of the filing of a petition, which is going to be most likely filed by the employer at this point, you're going to have 2 to 3 weeks at most between the date the petition is filed and the date of the election, when your employees are going to get to choose, by secret ballot, whether they want a union or not. And so think about that. I mean, because there's 3 pieces to this puzzle we're talking about today. We've talked about the Cemex decision, which essentially legitimizes card check and then puts the employer at their own peril to file an RN petition, and it makes it risky. And then you've got these quickie election rules, which compress the time frame if you do choose to have an election. So you will not have very long to respond. And then we've got this assault on small group meetings, where if you decide to go that route, you got to make sure that you do not require attendance, at least according to the NLRB's preference. Do not require attendance at these meetings. And if you do, then you've committed an unfair labor practice charge in NLRB's eyes. And then what does that get you? A bargaining. So you get a union. So things are changing quite a lot. In addition to that, we've got some new joint employer rules. That has been an issue that's gone back and forth over the last, I'd say, 10 years or so. Under the old Trump board rule, the business was a joint employer where it only had substantial direct immediate control over the essential terms and conditions of the company's employees. So of course, this issue arises when you have contingent workers or contract workers or 1099 workers who are on site at your place of business. And the question is, are they your employees for the purposes of National Labor Relations Act organizing? Can a union lump those workers in with yours for the purposes of elections and bargaining? Well, under this new board, the rule is 2 or more employers would be considered joint employers if they co-determine matters governing employees' essential terms and conditions of employment, such as wages, benefits, other compensation, work, training, hiring, discharge, discipline, workplace health, work rules, etc. It's not that the employers or the host employer has to actually exert control. They just reserve the right to engage in that control and co-determine those matters with the actual named employer. Then for the purposes of the National Labor Relations Act, they're going to be a joint employer, meaning that your employees and then the contract employees can be lumped together for the purposes of an election or for union representation. And so between the Cemex rule and the joint employer doctrine that's being adopted by the NLRB, this gives unions opportunity to secure cards from temps and contractors and make them part of a larger unit, wall-to-wall unit, which is basically every hourly, non-supervisory, non-security guard employee in the plant. Or they can chase micro units, meaning smaller departments within the whole business. So like a maintenance department or quality control department, to try to get a foothold into the business, and then later on maybe seek some larger unit election. So we talked about this a little bit earlier, the captive audience meeting issue. So bottom line, the NLRB views these meetings as being coercive and unlawful if attendance is required. And so the best practice now seems to be, if you're going to conduct these meetings, when you make the announcement, tell employees that that attendance is voluntary, they don't have to come. And then at the beginning of those meetings, to make the same disclaimer announcement, say, well, this attendance is not required. So if employees can get up and leave in the middle of the meetings without any disciplinary action, now they got to go back to work. But attendance would have to be voluntary. Now you can choose to ignore this and require attendance, have compulsory attendance, because technically right now, all we've got is a general counsel memo that says this is unlawful. We don't actually have a board ruling that says it's unlawful, but I suspect that will be coming soon. So just know, if you have a union campaign, you need to make a decision about whether you want to A, conduct small group meetings, and then B, are you going to require employees to attend and pay them while they're there, or are you going to excuse them? And then here we're going to talk a few minutes about this teamwear decision that came from the board last year. It regards Tesla. Everybody knows who Tesla is, electric vehicle manufacturer out there in California. So the UAW has been after Tesla for years. And in 2017, they had an active campaign at the Fremont, California plant. And Tesla, like many employers and manufacturers, had a teamwear policy that required employees to wear either a Tesla shirt or they could wear all black clothing. They could choose one of those two things. And as the UAW's campaign unfolded, a lot of the employees that support the union wore UAW t-shirts, wore UAW pins, some of which were metal pins, stickers, and other types of union paraphernalia. And Tesla disciplined employees for that, for violating the teamwear policy. And keep in mind, for years, the board had essentially allowed teamwear policies that, where employers could dictate, what employees wore to work. And they usually based it on safety, workplace decorum, and things like that. Well, in this case, the board said, look, any attempt to restrict the wearing of union clothing or insignia is presumptively unlawful. Meaning we're going to assume that your teamwear policy violates employees' rights to engage in protected concerted activity, to support, form, join, or assist a labor organization, and that an employer has a heightened burden to justify attempts to this important right, or attempts to limit this important right. So in other words, if you've got a teamwear policy, you need to start thinking about, what happens and how are you going to defend that policy if a union shows up at your doorstep and has its supporters showing up to the workplace in union paraphernalia, union shirts. You're going to have to demonstrate why you have that policy. And it needs to be based on some significant issues such as workplace safety, security, decorum. And the bottom line is, you may be able to prohibit union shirts that say vulgar, derogatory things about the company or a particular supervisor, but a t-shirt that just says union yes, that's it. You may have a hard time defending a policy that prohibits that. So you may need to take another look at your teamwear policies, or at least have a plan for what to do if you start seeing union paraphernalia show up in your workplace. And keep in mind, one of the things that Tesla prohibited was the wearing of metal pins of all kinds. It didn't have to be just a union pin, just any metal pin. Why? Well, their position was that those pins would damage the cars that the employees were manufacturing. And the NLRB said, no, that's not enough. You did not meet your heightened burden to demonstrate that prohibiting all metal pins was justified. So we've got a question and answer dialogue box down there. I don't see any questions here. If anybody has any, you can type them or maybe put them in the chat. But other than that, if nobody has any questions, I think we may be about done here. Any questions? Speak now, forever hold your peace. All right, well, I appreciate you all for joining us on this October Burr Morning Show. Have a great day, and stay tuned. We'll have another one of these next month. Oh wait, I think we have somebody just said thank you. Thank you, Sandra. All right, everybody have a great day. Take care.